Thank you all for being here. Today is very much a night in the spirit of education. We are all really busy parents. We all have a lot going on. There's a lot of stuff that we're expected to know that we don't know, and so that's kind of what we're doing tonight. Um, because you guys are investing in yourselves and because you're investing in your kids by doing this, we're turning this around and making it a spirit night for VOE. For everyone that's here, we'll donate $20 on your behalf to VOE, and that kind of lines up with our goal as a firm for supporting our local school and supporting public education. Okay, real quick. My name is Artie. I'm also a VOE parent like you guys. I have two kids at the school, a fourth grader named Asha in Miss Moody's class, a second grader named Anya in Miss Fox's class. Our kids have been through VOE really all through their formal public school education. I have been practicing for almost 20 years at this point. I started the law firm about 5 years ago. We are very education driven by design because I'm a big believer in knowing what your options are, right? There's a lot of things that we just don't know what we don't know. And especially when it comes to the world of estate planning, again, there's so much we're supposed to know that we don't know. And it doesn't allow us to operate from a place of knowledge and information. So today is really going to be focusing on the nuts and bolts of VOE. You can think, or VOE of estate planning, you can kind of think of this as what we're supposed to know as parents. What is estate planning? How can it help your family? Um, just what moving parts are we supposed to know, right? It's a very misunderstood or poorly understood area. So we'll touch on what the high points are. So we just get like a baseline education. So you just even know what you're supposed to be thinking about. When it comes to the world of estate planning, just to kind of break things down, there's a couple of moving pieces. There's your family, right? And we as parents of young children think about our family, we think about our kids, right? That's a really, really important piece. And we're going to drill down into that. That's that guardianship piece. That's the really uncomfortable piece of what do we do, right? What's the right call? What's the right decision? I will tell you that's why most young families procrastinate on estate planning because it's overwhelming, it's uncomfortable, and we just don't know what the answer is. And so we'll talk through a couple of tools there that can be helpful. We'll talk about assets, right? We have money, we have our own dollars in our bank accounts, and we just want to make sure it goes to the people we want it to go to. We want it to go to our kids. We may not want them to get it all outright at the age of 18 and make some crazy decisions. And so how do we get the dollars to the right people? And how do we just help them make good financially prudent decisions if that's something that's important to us? A part of estate planning is our comfort, right? As parents, we're not just the footnote. We need to be able to think about how do we want our wishes documented and recorded? What are our end of life decisions and choices? How do we want people to act on our behalf when we can't speak for ourselves? And then if we're a business owner, we want to think about that, right? What happens with a lot of business owners is if they don't think through the succession plan, there can be a fire sale at the end, and our family just doesn't get the dollars that they really should get or that we would hope for them to get. So that's kind of how we break down the building blocks and the pieces of estate planning. We'll talk more about those here in a second. Generally speaking, though, estate planning is it's a hard thing to think about, right, for families. And many times we're like, oh, we're young, or do we really need to do that? Or, do we really have the assets to really make it make sense? The world of estate planning, the better way to really think about it is we're doing it for our families and we're doing it for peace of mind. If we don't make the decisions for ourselves, the state of Texas makes the decision for us. And often those decisions are not aligned, right? But there's a plan in place, and we'll kind of talk about what that looks like. So over 70% of the population doesn't have a will or a trust or really any kind of planning. And so because of that, the state has to step in and the state has to have a plan for us. And so we'll kind of talk through that so you guys know what that looks like. Colloquially, when we hear about estate planning, the first thing most of us will hear about is this idea of a will, right? You got to get a will, you got to get a will. So one of the first decisions we make in the world of estate planning is, do we want a will or do we want a trust? And which one kind of lines up with how we just want to leave things to our families, or how we just how do we wish to kind of structure things, and what will things look like after we're gone? So if we have a will, so if we don't have any planning in place, or if we have a will, the default is something known as a court probate process. And you guys may have heard about the court probate process. The way that works, the court probate process is it's a one size fits all. It's a blanket policy, or it's a blanket probate court process for all Americans. It's actually designed very similarly to the bankruptcy process. So again, if we have a will or if we don't have a will, our families have to go through a court probate process. So how does that work? To this day, they make us file a publication in the newspaper that says, hey, these people passed away. If you want to bite at this apple or claim on this estate, show up on this date at this time to this courtroom and come and say your piece. And there are people that bounce around from courtroom to courtroom trying to get a bite of the apple. And the courts are really good at figuring out what's a valid claim and what's a bogus claim. But it's just something that your families have to go through, right? So they have to hire a probate attorney, and it really, all of it has to go through the courts. And it really, again, is designed for the benefit of the creditor, because all the creditors get paid first before our families can get what our families are owed, or what is left in the pot. Because of that, and because it's designed for the benefit of the creditor, they don't let us file anything under seal. So that means every asset you own, where it's parked, which kid it's going to, on which date, all of that is public record. It's a huge airing of your financial laundry, essentially. Your assets also get frozen at the court level until the court says, okay, we figured everything out. You can now release all these dollars to your family, and then you have to work with the judge and the court and the lawyers to retitle everything out of your names into your kids' names. So that's just what that general process looks like. It can take a while. As you can see, there's a lot of moving pieces here. It can get pretty expensive and get a bit unwieldy, and it's pretty involved. If you know anyone that's gone through a probate process, most of the times they will tell you 0 out of 0 stars, do not recommend. It can be very financially and emotionally exhausting. So just a quick summary of that is, again, if we have a will, we have to go through the probate process. It is public. The court is kind of in charge of it. Fees do add up if you happen to have assets in another state. If you have a home in Colorado or Florida or just anything anywhere, you'll have to have 2 separate probate processes running in both of those states. And it would not be unusual for it to take 6 to 9 months or possibly over a year. So it's a bit drawn out. For purposes of education, how do our kids inherit, either without a will or with a will? Minors cannot inherit. In America, kids cannot inherit until the age of 18. So all the assets have to go through probate, and then the judge appoints a financial guardian. That's almost like the financial gatekeeper of how dollars can be spent. Who does the judge choose as the financial guardian? We don't know. That really is up to the court, right? The court goes through testimony and witnesses, and they are the ones that get to decide who's basically going to become the new financial parent for our kids. And when do our kids receive their inheritance? It's at the age of 18. At the age of 18, if we do no additional planning, our kids get all of our money outright in their bank accounts without any protections on it or any parameters or any restrictions. So that's kind of when the financial guardian kind of lets it all flow into their bank accounts. And, at that point, it's their dollars, right? So they can do whatever they want with it and spend it however they choose to. Something else, just kind of an inadvertent side effect that we see happen is a lot of assets that they're not properly accounted for through estate planning, they will end up in the Department of Unclaimed Property. So if you think about this, right? Like if we were doing this for our parents, when I did this for my parents, they had all these random annuities and bank accounts and CDs and just scattered all around town. If I didn't know those existed, the default is they go to the state. That department at the state level is already $8 billion, primarily funded by people who just didn't know what their families owned, right? So again, just an important thing to keep in mind. It's at a bare minimum, it's just a really good idea to have some kind of asset inventory so that your kids or your family members who would be in charge of your affairs know what's out there, right? Because the idea obviously is we want to leave that to our children and not to, the government, right? Okay, so that is what that general process looks like. Again, so whether we have a will or don't have anything in place, it is a probate court-driven process. And if there's two of you, if you're married, you have to go through the process after the first death and then again after the second death. So it's kind of two cycles of the court. I will tell you that there has been a very strong push um, for families who have not wanted to obviously go through that at their at the court level, right? They're like, how do we avoid this airing of our financial laundry? How do we keep things private? How do we keep dollars flowing down seamlessly to our kids? And so because of that, there have been additional options that are really being made available at this point for families who just want things streamlined and just a little bit more straightforward and clear. And so the option that we've really seen kind of bubble to the top is this idea of a living trust, right? I think for a long time there was this misconception that a trust was only reserved for the uber wealthy, right? Like only rich people had trusts. And the conversation in the last decade or so has moved away from the idea of a trust being a vehicle that holds boatloads of money and really more towards the idea of it being preference driven, right? We use a trust if we want to bypass things like court, if we want to keep things private and so on. So what is a trust? A trust is essentially a will substitute. Like I said at the beginning, we can either have a will-based plan or a trust-based plan. That's what the trust is. It is our way of avoiding probate because there's a lot of families that just don't want their families to have to go through probate. They don't just want to keep the courts out of it. They kind of want to wrap things up with a bow on top. They just want it to be easy, seamless, private, immediate, right? So especially if you have young kids, how do we have our dollars flow down immediately? And that's something we can do by bypassing the court probate process. So if you remember the slide I shared a little bit ago, you saw the probate process and how it was just really long and kind of snaked out. It's just much more straightforward when we have a trust in place. We notify beneficiaries, we marshal the assets, we either liquidate them or pass them on, we distribute, and then you're kind of done. Again, because of the way that the trust works, we don't have to go through the court process. Everything is private and dollars flow immediately. And so the idea of how this works is in one way or another, we connect all of our assets to a trust, right? So for a home, a real estate attorney will deed it into a trust. So now the home is owned by the trust, right? So if we look it up on the appraisal district website, the home is owned by the trust. For things like life insurance and retirement accounts and so on, you change beneficiary designations to the trust. The idea is in one way or another, you link all of your assets to this trust. And so now if something were to happen, we don't have to go through the courts because everything is linked to the trust and all those dollars are pouring into the trust, we get to bypass the court's involvement in its entirety. And so that's why dollars kind of become immediately available. Again, I would say having a plan is better than no plan because at least you're able to voice your wishes, right? You're able to say, hey, I have 3 kids and I want it to split 33, 33, 33. And maybe I don't want the dollars to be available to them until they're 21 or so on. But again, going the will route does mean that you have to go through probate. I will tell you about 90% of our clients now are starting to go the trust route, especially if they're younger kids. It is actually the more economical route too. It is much more economical because you just don't have to go through the courts. You don't have to go through the hiring the attorney and the probate and so on. So again, having a plan is better than no plan, but this is really a part of the education piece, right? Because we don't know what options are available until we kind of talk through them. And again, definitely the most cost-effective route. Okay, so that is the asset piece. Like when I showed you earlier, we had a couple of puzzle pieces. We've talked through the asset piece because that's probably the hardest one to kind of wrap our heads around and conceptualize. The next piece we're going to move on to that is actually super important, probably the most important piece for us as parents, for any parents really, is this idea of guardianship, right? Again, I mentioned this earlier. This is why we see a lot of young families not plan because it is uncomfortable to think about. Sometimes it's excruciating to think about. And it always feels like there's not going to be the next perfect person to handle, to take on your children, or no one's going to do it as good as you, or, no one's really just doesn't have all the parts that we're kind of looking for in raising our children. So I'm going to put this out there, and I'm going to say this more to educate and not to alarm, because we have solutions for everything. But this is a really important piece to understand. If we don't have guardians lined up, the default for our children is foster care. And I know that sounds insane, and I know that sounds almost incomprehensible. But if you think about it, if we just kind of break this down for a second, let's just say we're coming home from a date night, right? And there was a car accident, something happened. Okay. And let's say a sweet little lady, sweet grandma, shows up at the scene and wants to take your kids over. It could be grandma, it could be someone they spend every day with. But a first responder is not going to pass your children on to grandma because they don't know if that's a safe environment for your kids, right? There could be many factors at play, and they're just not going to take on that liability as the state or just in general, right? And so the way this plays out is our kids actually go into the state's care until a spot is made available on a judge's calendar. And then there's a hearing, and the judge listens to testimony and witnesses and so on. And the judge decides where our kids go. And it may not be, obviously, what we may have thought, right? Like we may have a brother in town who is really savvy and looks amazing on paper, but maybe for other reasons, that's not what we would have chosen, right? Again, if we don't make the choice, court makes the choice for us. So again, this is a super difficult thing to consider, a super difficult thing to kind of, figure out the answer on, right? And so we have these conversations all the time at the firm and come up kind of like with a checklist or a worksheet for couples to work through. Because the other thing that happens if you have a married couple coming through is they may have different thoughts on who they want the kids to go to, right? And that's okay. I mean, all of this is uncomfortable, but it's important to know that you're not the only one that's going through this, right? So when it comes to picking guardians, the one thing I always like to say is it's better to pick guardians who are more value aligned with you, right? Rather than being overly focused on, hey, this person may not have the bandwidth, or this person may live in a shoebox, or so on. So, many times we'll have clients that are talking about, well, my sister would be great, but she lives in a shoebox in New York, or this really tight apartment in California. And so the one thing we should remember is our kids go with buckets of dollars with them, right? They're attached with bags of money, and those dollars can be spent in any way necessary to essentially maximize, their best interests, right? To provide for our kids. So, if it's a family member living in a shoebox, they can use those dollars towards buying a larger home, right? If it's someone who's really strapped on time, those dollars can be used towards an au pair or additional childcare help, right? What we can't replace is the home that the kids go into. So that's generally, kind of what we think about when it comes to guardians. Sometimes it gets tricky, right? Because maybe the person we want to pick lives in North Carolina, but we want our kids to stay in this community here. And so we kind of can talk through a lot of the pros and the cons and, kind of reach whatever the best potential or possible decision is there. Okay, along with us talking about guardians, something else that's overlooked, and this is something we've kind of added to all of our plans. If the guardians that we pick live, again, a further drive away like Dallas or New York or California or Florida, the default is still foster care until those guardians can arrive. And so something we do at the firm is we will do short-term guardians or emergency guardians. That's what we call them. So we'll do emergency guardians and long-term guardians. The emergency guardians are kind of a short-term interim post to basically hold over, be able to get the kids at the scene, right? Be able to be vested with that power and appointed with that power to be able to get the kids from the first responder until our long-term guardians can arrive. So again, this is to provide minimal disruption for the kids in that moment of chaos, essentially, right? And just not knowing the uncertainty of that moment. Okay. Another piece that's really important in the world of estate planning is us, right? There's the financial piece. How do we get our money to our kids and in what way and how and when? There's the guardianship piece, worst case scenario. where do our kids go? And then there's the us piece, right? Who speaks for us when we can't speak for ourselves? And so this piece includes the financial power of attorney who can reach into our bank accounts when we're in a coma and can't do it ourselves. The healthcare power of attorney, that's who can speak at our bedside when we can't communicate with doctors ourselves. And then that healthcare directive, or what we call a living will. How do we feel about end of life comfort care, life support, those kinds of things? Obviously, at a time of incapacity planning, you're not really in control. So the idea here is to try to stay in control with effective incapacity planning and kind of getting ahead of it and being able to document what's important to you, right? So having your wishes documented and then also having them documented to the point where we can remove the guesswork for our families. I think most of us are probably old enough that we remember the Terry Schiavo case, which played out in the media and was just painful to watch. And so that's what this speaks to. How do we make sure that we have all the parts accounted for? Okay, so I'm going to now kind of go through a couple of the things that we talked about because we kind of hit on the high points, and then I'm happy to answer any questions at the end. So the first big takeaway, if there's any takeaway that you can walk away with today, I would say the most important part is really thinking through your guardianship choices. It is always going to be better for us to make that decision than for the courts deciding for us. Even if it's uncomfortable, we're still likely to be able to make the better decision, right? Another thing to just know is that whatever we do is better than having not done anything, right? So that's the first piece. But also whatever we document can be changed over time, right? And so sometimes we'll have a client that will say, I would love for my mom to be the guardian of my kids, but my mom is 70, right? And so sometimes if it's a difficult decision to make, we can think about it in more bite-sized pieces where if we need to pick someone for the next 3 years or the next 5 years, who would that be, right? And that answer for the 3 years or the 5 years may be different than the person, that we may pick 10 years down the road, right? And so again, just knowing that we have that flexibility, because when we sometimes think about it in bite-sized chunks, it's an easier decision to make. But this is a really important one, if not the most important thing for us to kind of consider as parents and make sure everything is really buttoned up there. And something else we do whenever we name anyone in any capacity is we will name one person with 2 backups, right? Because we don't know how life plays out. And if someone was to predecease us, we don't want to be held in this lurch and just not really even know how that would unfold, right? So the threshold is if person number 1 is unable or unwilling, we can move down to person number 2, and then person number 3 if we've named a person number 3. Okay, second big lesson is having a plan is better than no plan. But again, it's just knowing about your options, right? Colloquially, again, you'll hear a lot about people talking about a will. In full transparency, I will tell you there are a lot of attorneys that prepare wills because probates are very, very lucrative for attorneys, right? And so if they draft your will, they will most likely get your probate work too. But from the perspective of a family, that can be a pretty long, drawn out public process. It can be an expensive process. And again, we're seeing a really strong shift towards families picking this idea of the trust to, again, be able to get the dollars to their kids immediately and kind of in a more private manner. Okay. Lesson number 3 is planning keeps you in control, right? Estate planning requires intentional action. If we don't do estate planning ourselves, again, the state of Texas has a plan. Often it's not the ideal plan. Estate planning allows us to decide who gets our dollars, how they get it, when they get it, along with, hey, where do our kids go? What choices do we want to make for ourselves and so on, right? So again, in a world full of uncertainty sometimes, and when we talk about things like death and passing, this is what allows us to kind of hold onto the control a little bit. Okay, so I've gone over most of the main points. I will just go through this. Today, like I said, is very much intended to be a spirit night and a night of education, but I get asked this question a lot, so I will just put this out there and say, if you want to do estate planning, and if you are interested in doing estate planning, there are many estate planning law firms around town, and I would just encourage you to do it. If you wanted to talk further and you wanted to talk to us, we're happy to talk to you. There's a lot of things that we do to kind of add just additional features onto our plans that are very much created by our plans because we noted what the industry points of failure are. So we do no hourly billing because I'm a big believer in conversation and education and really figuring out what the right fit is for each family. So everything is custom design. We don't charge for our time or our sessions or our meetings. Everything is flat fee and transparent. We do complimentary 5-year reviews with all of our plans, and we just stay engaged. So the goal is, hey, let's have the plan grow with you, and let's do what you need to do as a family, right? And if you wanted to do estate planning, just again, this is more from the education perspective. You can get a will-based plan or a trust-based plan. These numbers are specific to our firm. Our will-based plans start in the 2000s. Our trust-based plans start in the 4000s. Again, we're starting to see a lot more families do trusts. I would rather a family do something, but I'm just telling you that we're starting to see a lot more do trusts. That sounds like the more expensive option. It is by far the more economical option when we think of total cost of ownership, right? At its most basic level, a trust will keep you out of probate. It will keep things clean and buttoned up for your family, and it can save thousands of dollars if you wanted to build an additional tax strategy or asset protection. Plans can save hundreds of thousands, if not millions of dollars over the course of your lifetime because there's a lot we can do to bypass taxes and bypass costs and so on. So again, there's just a lot of options open. And for anyone that has young children, we always do what we call the ever after plan, which is guardianship stuff, right? Long-term guardians, short-term guardians. We create wallet cards for first responders because we know first responders check wallets. And then actually for all minor children, we also do medical minor powers of attorney, which is really important, right? So if we as parents are unavailable, there's a document there that allows for our kids to still get medical attention because there's a medical power of attorney created for our kids. Okay, and then real quick, again, just in the spirit of education, today, all I really want today is for you guys to have a little bit more understanding of the world of estate planning and things we should think about as parents, right? Like planting the seeds and kind of stewing over these decisions. But estate planning is one of those things that you kind of have to be ready to rise to the occasion and be ready to do it. But if you decide you want to, again, invest in your family and do a plan, that's an if on your side. Going back to the whole supporting public education, we are making a donation on behalf of every VOE family that wants to plan. So we have committed to making a $250 donation to VOE for any VOE family that chooses to plan with us. In general, I like to think that we are approachable and relatable as a law firm. So if you have any questions on anything we've talked about at all today, please feel free to reach out. Feel free to ask me anything you want. We welcome the conversation. I just want, it's important to me that you be able to kind of have the answers that you need and kind of be able to talk through the things that are important to you so you can make the right choices for you and your family. Okay, y'all, we covered a lot of heavy stuff. So at this point, I am happy to take any questions if you guys have questions. I will go to the chat and you guys just tell me if you have any questions. Okay, I'm seeing a question about the court process and how the court process works. Yeah, that's what we call the probate process. So that is what we were talking about earlier. The way that works is if we don't have a plan at all, we have to file something after the first death. And then if we're a married couple, we have to file something after the first death and then again after the second death. So that's just how it works. The reason we have to do it that way is because assets are still in our personal name. So real estate, for example, when real estate is in our personal name, we have to go through the courts to transfer that asset, right? And same with things like bank accounts and brokerage accounts and so on. And so that's why that probate process is designed that way, rather than the trust. If you have everything owned or linked rather to the trust, then those dollars immediately flow down as we designate in the trust document. I will say that the trust is a little bit more work now because it does require us linking things to the trust. It also requires us um, to, beyond just like linking things, it requires us to, um, make the transfers, right? And just doing a little bit more legwork now. But there's nothing that we do at the trust level that our kids or our families would not have to do later, right? So someone else would have to do it later if we just don't take care of it. Okay, I'm seeing another question about how can we talk more to you. You can use any of these emails or that Calendly link is how you can schedule some time. I'm always happy to have the conversation. And if there's any questions that you guys have, feel free to reach out. Okay, I will stay on a little bit longer if there are any additional questions, but otherwise, thank you guys for investing in yourselves and your families and asking the questions and getting the information. That is a step in the right direction. And now hopefully, you know a little bit more than you did before, and you can just start thinking about these key things that are important puzzle pieces to know. Oh, okay. One more question. With a living trust, if one parent dies, will the living parent still handle the trust? Yes, absolutely. So if there are two parents, right? If it's a husband and wife family, whenever we talk about the trust, we talk about what happens at the first death and then what happens at the second death. If it's a single parent family, then obviously it's just like after that one death, right? But we talk about what happens at the first death, what happens at the second death. And again, there's a lot of options and a lot of tools that we have. So most often the surviving parent is the one who's going to have full control of that pot of money, right? The surviving parent will have their hands on 100% of those dollars. However, sometimes that's not actually what the family wants to do. It sounds like it's what they want to do, but as we talk through things, that may not actually be the intention. For example, if one of the parents passes away pretty young and say there's a remarriage, right? If there is a remarriage, if for example, if I was talking about my life, right? And if my husband was to pass away and I were to remarry, if I die before my next husband, or if I pass away before my next husband, inadvertently, all of our assets could get commingled. And inadvertently, my husband number two could have all those dollars move on to him and his kids, and I could inadvertently carve out my kids, right? So there's a lot of ways that we can kind of fashion and design things to make sure, hey, worst case scenario, if everything hits the fan, if there's lawsuits, car accidents, remarriages, how do we protect that pot for our kids? How do we make sure it actually goes to our kids and not to other third parties? So yeah, there's a lot we can do. Another thing that we see come up a lot is how do we leave our dollars to our kids when they're really young, right? And so there are ways that we can say, that we can add parameters if we want to, right? When they're younger, it's like we're protecting them from themselves. They get a whole bunch of money. But when they're older, it's like we're protecting them from external influences, right? If they were to get divorced, how do we make sure they don't lose half of their assets in a divorce? Again, lawsuits, car accidents, those kinds of things. So there's a lot of different protection mechanisms, and it's a conversation worth having because it's things that we just don't think about that can be pretty significant and really kind of alter the course of where our dollars end up. Okay, you guys, I am gonna let y'all go. I think I will go ahead and end. Thank you guys for being on. Again, if you have any questions, feel free to reach